And in that case, there's a young man, a young male, the police see him, he sees them, and he runs away.
California versus Hodari D case from the Supreme Court. That
Hold on. Let me stop you there.
And I can't do anything about it. Hey, nice to see you, officer. Nice uniform.
I have to object to this question on relevance grounds.
I don't think you're disagreeing to that, are you? I'm loving this, by the way, so I thank you both.
At Michigan's 34th District Court, Phillip Lloyd appeared before Judge Oakley at a preliminary examination after being arrested outside a Citco gas station in the early morning hours of March 29, 2025. What brought officers there was a harassment call, but what followed quickly turned into a Fourth Amendment fight. The defense came into court relying on two Supreme Court decisions, Terry versus Ohio and California versus Hodari D, and argued that the moment the officer told Lloyd to come over, he had already been seized, without the reasonable suspicion the Constitution requires. Under the exclusionary rule, evidence that comes from an unlawful seizure cannot be used against a defendant at trial, and the Fourth Amendment does not exist only to protect the guilty. It also defines how far law enforcement can go before they have enough legal basis to act. Judge Oakley was about to hear sharp arguments from both sides of that constitutional line before deciding whether the case could move forward at all.
Understood. First witness, raise your right hand. Swear affirm to tell the truth, the whole truth, nothing but the truth?
Swear.
Yeah, can you lose a hat?
Yes, sir.
Thank you. Have a seat. When you're ready, Mr. Cavill.
Nick, state your name, sir.
Officer Zachary Sequina.
Are you employed?
I am.
Work for the police department, Ms. Ramos? How many years have you been a police officer? How do you spell your list?
SCICLUNA.
Officer, were you working on March 29th of 2025 at about 1 in the morning?
Yes, sir.
Did you have the occasion to be at a Citco gas station in Romulus?
Yes, sir.
Remember the address?
5820 Middlebelt.
That's in Romulus? Sir, during your course of duties on that evening, did you meet a gentleman named Phillip Lloyd?
Yes, sir.
If you saw Phillip Lloyd again, did you recognize him?
I will.
Look around the corner and let Judge Oakley know whether you see Phillip Lloyd.
I do see you, Phillip Lloyd. Here, sir.
What's he wearing?
He is wearing a orange shirt with a white undershirt.
Noted.
Identify defendant Phillip Lloyd.
So noted.
Thank you, Your Honor. Are you wearing uniform or plain clothes?
Either one.
Well, sir, where do you meet Mr. Lloyd?
I'm sorry.
Where do you meet Mr. Lloyd, Phillip Lloyd?
I met him at the Citco Gas Station.
Why were you at the Citco gas station?
The gas station clerk called us there for a person harassing.
You object at this point to any statements made by Citco gas clerk.
Sent out for the truth of the matter, sir. She could be the biggest liar. She could be Pinocchio. Fact is, the employee is giving the police officer information, whether it's true or false. He can act on it. So, Senator, sent out for the truth of the matter, sir.
Well, I'm not even sure that a foundation is laid. The statement was made to Officer Sequina, or that Officer Sequina heard the content of the statement.
And that's because there was an interjection before I asked.
I'll let you lay foundation.
Speak at the gas station.
It was a dispatch call from.
Did you receive the dispatch or was it another officer?
The dispatcher received the call and they put it over the radio to my unit.
Did you talk to the dispatcher?
Over the radio, yes.
So what information were you given about the Citco gas station?
The gas station had called referencing a black male.
Again, I'm going to object. So now we're into double hearsay. We're into.
Or not hearsay at all if it's not introduced for the truth of the matter asserted. Which it's not. It's introduced to establish why he went to the Citco. So I'll overrule the objection. You're welcome.
Again, why did you go to the Citco station?
We were dispatched to the gas station for a male harassing customer.
Were you given a description of him?
I was.
What description were you given?
It's in my report. If I could look at.
With reviewing the report, refresh your memory.
It was.
Judge, does he have permission to review this report?
Absolutely.
Is your memory revived?
It is.
Officer, what description were you given?
I was advised there was a male wearing a black sweatshirt and black boots.
Did you notice anybody at the Citco station matching that description?
Yes, sir.
How many people did you see at the Citco gas station at 1 in the morning matching the description provided me by dispatch?
Just the one, sir.
And who was that person?
Phillip Lloyd.
Did you learn from Mr. Lloyd his name? How do you gain Mr. Lloyd's name from Mr. Lloyd?
I asked him,
You asked him what?
I asked him for his ID. He advised he did not have one and identified himself by word of mouth.
Sir, do you eventually gain his name though, Phillip Lloyd?
Yes,
How do you gain that name?
he told me his name.
When he told you his name, what steps did you take, if any?
I wrote it down in the lien search of Mr. Phillip Lloyd.
When you asked Mr. Lloyd his name, had you arrested him first?
No,
Had you handcuffed him?
no,
Had you placed him in custody?
no.
Did you threaten him in any way? Well, armed with the knowledge that you had a man named Phillip Lloyd near you or with you. Well, by the way, where is he at the gas station when you see him?
He is sitting on the walkway of the gas station
Outside or inside?
outside.
Armed with the information that this person might be Phillip Lloyd, what steps do you take?
I conducted a lien search of the person named Phillip Lloyd and confirmed that it was him with the photograph at lien/SOS provides and
SOS is what?
Secretary of State.
But what did you conclude after reviewing the Secretary of State photo?
I found out that he had warrants for his arrest.
As a result of learning that Mr. Lloyd had warrants against him for his arrest, what did you do?
Placed him in handcuffs and arrested.
Find any firearms? Where?
It was in his right sweatpants pocket.
What?
The revolver, the Smith & Wesson revolver.
What did you do with that weapon when you noticed that it was confiscated?
My partner took it to the rear of the patrol vehicle and made it safe.
Now, sir, did you attempt to determine whether this defendant, Mr. Lloyd, had a valid and current CPL on the date of this incident?
I did. I not only asked him, but I asked my dispatch to run in for a CPL as well.
When you asked Mr. Lloyd whether he had a CPL, how did he respond?
He advised that he did not have a CPL.
What information did you gain from the lien whether Mr. Lloyd possessed a valid and current CPL?
I learned that he did not have a CPL.
Sir, are you in a position to tell Judge Oakley about the state of sobriety of Mr. Lloyd when you encountered him?
Object as to relevance, it's not relevant to the charge element.
I'm seeking that account of possession of a firearm while under the influence of alcohol.
That would be a misdemeanor count for which neither the people nor the defense has right to a preliminary exam.
That is not correct. He doesn't have a right to a preliminary examination on that count, but I have to still prove it because it's not included in the original complaint. Or I can move to amend the complaint and say on the count, and then you don't have to make findings. Do it either way, whatever you prefer.
I'll allow it.
What conclusion, if any, did you read about the state of sobriety of this defendant?
When we first approached him, I noticed he was unsteady, had an unsteady gait, and eventually needed a garbage can to steady his balance. When approaching him, the odor of intoxicants was emanated from this person.
Can you estimate for Judge Oakley the number of drunk driving capers you've been involved in as a police officer?
Did you just say caper?
It's a prize.
It worked.
You've had, haven't you?
More than 5?
And what conclusion did you reach as to whether you're sober or innocent?
I saw he was not sober.
Thank you.
Mr. Martin, your witness?
Good morning, Officer Spuna.
Mornings.
So a few questions for you. Just briefly, you say as of now, you've been a police officer for about 1.5 years.
That's correct.
So as of March 29th, 2025, the day of this incident, how recently had you become a police officer?
So I graduated the academy November 11th.
November 11th of 2024.
Correct.
Thank you. And then immediately you joined the Romulus Police Department? Okay. And then as of that time, you mentioned that in your career, you've done more than 5 drunk driving investigations. How many do you think you had done as of March 29th, 2025?
I'm not sure.
So, as you, just to confirm what you stated on direct, you're dispatched to this location, the gas station, but at that point, you had not spoken to any employee or citizen who was at the gas station, right?
That is correct.
And the information you received from dispatch, it didn't describe crime taking place at the gas station. Wouldn't you agree?
I was dispatched to a male harassing customers at a gas station.
Harassing. But that's not a report of an assault, right?
Correct.
Not a report of trespassing.
Correct.
and you didn't have any more detail beyond the word harassing. So you and your partner pull up to this gas station in a fully marked patrol car.
Correct.
You and your partner are both fully uniformed.
Correct.
And as soon as you pull up, you and your partner hop out of the car,
Step out of the car.
step out of the car, and you immediately see the person later identified as Mr. Lloyd outside the gas station.
That's correct.
You never go in the gas station,
That's correct.
and there's no one else outside, right?
That's correct.
So you don't see him interacting with any other person.
At the time, that is correct.
You don't see him committing anything that would be called harassment. And you don't observe any sort of, bulge consistent with a firearm at that time when you first see him, right?
That is correct.
Okay. And you see him, but you didn't recognize him from any prior interaction, no?
I did not recognize him.
And as soon as you see him, would you agree that your words to him were, "What's going on? Come here." And so at that point, you've given him an official order to come towards you, right?
I would say so, yes.
Yes. He's not free to leave at that point, right?
In the circumstances, I would say yes.
Thank you. Both, and this is at the point where you're giving him that order, you don't yet know this person's name, right?
Right.
You don't know anything about if he has warrants. You don't know anything about intoxication,
Correct.
right?
So we
And-
can fall.
When you say those words, "Hey, come here," his body at that moment, he was kind of walking away from the front door of the gas station. Would you agree?
That's correct.
Okay. Safe to say he was not approaching you when you made that order, right?
Correct.
Okay. But then as soon as you make that order, he submitted to your order and came to you and your partner, right? At that point, you began questioning or interviewing some kind of. And so when you eventually discover this firearm, that's due to a search incident to arrest on the warrants, right?
Yes.
Okay, it's not some sort of, you don't perform a Terry frisk prior to arresting him on the warrants. You never performed any sort of field sobriety tests on him, right?
That is correct.
No breathalyzer.
Correct.
And no blood draw that you're aware of. I have nothing to.
Victor, have you responded to other calls involving harassment?
I have.
And give us a range of different types of harassment cases you've investigated as a responding officer.
I have to object to this question on relevance grounds, or speculation. I don't see how other harassment, calls that Officer Scicluna has responded to could possibly be relevant to this case, where all we've heard is that dispatch told him harassment with no further details.
So it's counsel who raises the issue about, he calls it harassment, it's harassment. But he's the one who raises about harassment. What was he doing? Did he commit a crime? I now have a right to elicit for you, the finder of fact, what harassment can mean. It's not as though he's there selling cookies. Somebody filed a complaint and he's investigating. Harassment could be a touching, it could be profanity, and we also know he's under the influence. He has the right to determine who this person is.
And
As part of the scene.
I just want to briefly respond that Mr. Kaplan said this person filed a complaint. That's not really true. All we know is that there may have been a 911 call, but nothing about filing a complaint, which is a formal process.
I think the court can take judicial notice and apply common sense here. 911 called him. Somebody obviously called the 911 dispatcher. She didn't drive to the gas station and fill her tank during the day or at night. So I want to know what harassment can mean to him, because it gives him the right to investigate.
I'll allow it.
Harassment, if you have cases involving harassment calls,
I have.
then give us the range. Tell us what types. We don't need an hour to sell it, but what types of cases are we talking?
I've responded to harassment cases involving constant contact over the telephone, constant unconsensual contact in person, a wide range of harassment cases.
Thank you.
Any recross? Oh, so you can step down. Watch your step on my ramp. Any other witnesses?
People risk.
Any defense witnesses? I'm ready for argument, fellas.
Notice, we always do, we didn't present any proofs regarding felon and possession of firearms. It's not as though it's found. It has to reopen proofs. Without going into large details here, we don't have proof at this point to show that the gentleman, Mr. Lloyd, was a felon in possession of a firearm. We asked Your Honor to bind the case over on 2 counts. We know it's unusual and misdemeanor, but carrying a concealed weapon and possession of a firearm while under the influence of liquor, that's a 90-day misdemeanor. So what do we have here? We have an officer on patrol with a partner wearing a uniform and a marked scout car, and he receives a call from dispatch. Now, that is very common. That's how they communicate. Dispatch says there's a guy at the gas station harassing people, something along those lines. And a description is given, not only of the gentleman's race, but his height and what he's wearing. Officer arrives, sees a guy, one guy, not 100, not 50. He sees the defendant. Defendant is outside. It's close enough to him at some point to see he's under the influence of liquor. Now, Terry v. Ohio allows an officer to stop, detain, and question a person when there's reasonable suspicion that he might have committed a crime, attempted to commit a crime, or is about to commit a crime. And at this point, in 1 a.m, they see a man who allegedly has been harassing people. They have a right to investigate. He asked them a simple question. What is your name? What is your name? And he doesn't have a licensed judge, but finally he says, it's Phillip Lloyd. And guess what? Mr. Lloyd has warrants against him. So they arrest him, they search him, they find the guns. There's no Fourth Amendment violation there. We seek a minor vote.
Mr. Martin.
Thank you, Judge. So first to address what Mr. Kaplan just said about some of these counts, they're now looking to bind over on 1, 2, 4, or 5. So of course, defense moves for dismissal of those counts.
Done.
Furthermore, I'd like to address the added count next, this proposed misdemeanor, which Your Honor did allow Mr. Kaplan to ask questions regarding that count on his exam. So if I may offer some counter argument, even Mr. Kaplan having the opportunity to make a record of this misdemeanor count, the only record he made is possible observations of suspected intoxication in a case where there's no field sobriety tests, no breath, no blood. I mean, we're speculating here. This isn't a driving case, so those things wouldn't exist. So this person has never met Mr. Lloyd before, doesn't know his disposition, doesn't know anything about his mental health. So I think that we're grasping at straws here, and that count should not be bound over. Now, finally, if I can turn to the remaining felony CCW count, where we are objecting to bind over on Fourth Amendment grounds. As Mr. Kaplan alluded to, I believe that there is a Fourth Amendment violation here. If I can just explain what that looks like, I think that the controlling case here would be the California versus Hodari D case from the Supreme Court. That citation is 499 U.S. 621. That's a 1991 case written by Justice Scalia. And that's really the case that stands for the proposition that when does a seizure occur? If an officer has not used physical force on someone, if an officer gives an order that says, hey, you stop, and that person runs away, that person has not been seized for Fourth Amendment purposes. But if an officer gives an order that says, hey, you stop, and it's a lawful order, the person then submits to that show of authority, that is the moment of seizure for Fourth Amendment purposes. It's really a question of, does this person feel free to leave in that situation? And we even had Officer Sakuna agreeing that once he's given a lawful order to Mr. Lloyd, that Mr. Lloyd is not free to leave. So let's think about what is known to the officer at the time when he gives that order, that seizure. He doesn't know Mr. Lloyd's name, doesn't know anything about Mr. Lloyd having a warrant referred to. Terry versus Ohio would require reasonable suspicion that Mr. Lloyd is armed and dangerous at that time. And we had testimony that there was no observation of any sort of firearm-shaped bulge. So there's nothing in the report to say, hey, this man is harassing people and he has a gun. There's nothing like that. So there's no reasonable suspicion that he's armed. And I think that alone should cause it to fail. How many Terry cases have you seen where it's based on suspicion that a person has a gun? That suspicion did not exist here until he's being
search incident to arrest on these warrants that were, again, unknown at the time of this Fourth Amendment seizure. So that's why I do believe there's a Fourth Amendment problem here, and that the evidence seized, namely the firearm, is the fruit of a Fourth Amendment violation, and therefore the case should not be bound over. Thank you, Judge.
You're welcome.
So I too am familiar with California versus Hodari D. And in that case, there's a young man, a young male, the police see him, he sees them, and he runs away. This defendant runs away, and the police run after him. And the court says, there's no seizure, he ran away. Now, in this case, I'd like you to imagine, we live in a world where under these circumstances, an officer has to say, oh, I see this guy, he matches the description of somebody who allegedly was harassing people at the gas station, and I can't do anything about it. Hey, nice to see you, officer, nice uniform, have a good life. That's not the case. The police have a right to investigate. It's 1 a.m, there's a harassment call, it can only be one guy, he matches the description. If he can't say, oh, hey, come here, what's your name? I don't want to live in that world, because that would mean that many of the arrests that officers made, many of the collars they made, many of the stops, they're not good. They're not good. This case involves reasonable suspicion based on the time of the day, the actions of the defendant, and I'm not even sure asking somebody's name is a inquisitorial matter. We all have a name, and ask them his name.
I'll give you another shot.
I would say, we're thinking about, oh, how do we avoid a situation where every single interaction like this is a Fourth Amendment violation? Well, a police officer in that situation can arrive at the scene and do more to investigate before they start telling people to come to them and implying that they're not free to leave. Obviously, the officers could have entered the gas station first, tried to find out who made this call and learn some more information. Instead, they see a single person, gives him an order, and at that point start investigating when they've learned nothing about what happened. So I think that they went about this wrong.
I just want to make sure I understand the argument, Mr. Martin, because I think what your argument is that based on what they got from dispatch alone, they did not have enough to investigate the gentleman they saw outside the station.
If you think about, my argument is when they say, hey, come here, that is a seizure for Fourth Amendment purposes.
I think we would all, I don't think you're disagreeing to that, are you?
No.
Well, I think we all agree that was a seizure.
That's a seizure.
Yeah.
So what's the lowest standard in Fourth Amendment law?
Right.
Reasonable suspicion. So is there reasonable suspicion at that time? So if it's, and there's reasonable suspicion for Terry's purposes, that's armed and dangerous, I don't think that's met.
I would agree.
For reasonable suspicion also appears in the traffic stop context, reasonable suspicion of a traffic violation. That's obviously not present here. Reasonable suspicion of a crime, I don't think that's relevant either. And in fact, that's...
Hold on. Let me stop you there, because I think we all agree that's where we disagree. You think there was reasonable suspicion of a crime triggered at that point. You don't. Am I right?
I would modify someone reasonable.
Go ahead.
Had committed a crime, attempted to commit a crime, or is about to commit a crime.
Fair enough. Do we agree that's where the split is between you two?
I agree with that.
Okay, go ahead then.
One more piece of law on the record.
Sure.
I'm sorry, I didn't have this at the ready, but there is a piece of Michigan law, I'm trying to find the correct MCL, that talks about the circumstances where an officer is authorized to make an arrest. And while I'm fumbling for the exact citation right now, it is when circumstances where there's no warrant, there's a piece of Michigan law that says that an officer may arrest when a felony or misdemeanor is committed in their presence, or if they have reason to believe that a misdemeanor of a certain severity was committed even outside of their presence. And under that law, I don't think that the standard is met here either.
I would agree with you. Yeah, I think the question is whether or not, based on the dispatch call only, they had a reasonable suspicion. Because you don't think they do without more investigation before they seize.
I agree. I think it'd be different if the dispatch call said, he's intimidating other customers and making them feel unsafe. I mean, that might be reasonable suspicion of some sort of assault or threat, or he's been told to leave and he's not leaving, reasonable suspicion of a trespass. But this scant amount of detail, and we don't have dispatch records. I mean, they could have brought in the CAD report from the 911 call and have someone authenticate that. I don't even have that in discovery. So we're just not going off of enough here. And you're making someone feel not safe to leave. Well, just go into the gas station, talk to the clerk, learn some more information first. So then you're doing this investigation based on personal knowledge and not just stopping people on the street based on this extremely undetailed, unspecific report that you got through the dispatch.
Mr. Catlin,
If we accept,
I'm loving this, by the way, so I thank you both.
he doesn't have to stay, and we say, stay here, we're gonna investigate what happened in the gas station, that would be a seizure. That's not what happened here. When you put on your rope this morning, you didn't leave your common sense behind. The fact is, it would be misconduct on the part of the officer to say, hey, I'm leaving. I have other things to do. I want to stop at Dunkin' Donuts. That would be misconduct in office. He probably would lose his job if he just said, let it go. He has to investigate in the way he did. Hey, what's your name? How incriminating is what's your name? How many of us have outstanding warrants as this man did? He's the one with the warrants. He's the one who didn't show up at court. He's the one where the officers have to arrest him when they learn about him.
Right, thank you, gentlemen. I'm going to bind over on count 3 only. I understand your argument, Mr. Martin, that the dispatch call that there's a black male wearing a black hoodie and black pants that's been harassing customers is not enough detail, but I think it is enough detail for an investigation. And I don't think an investigation that starts with what's your name is onerous. So I'm gonna bind over only on count 3. I agree with your argument on the under the influence carrying a weapon. Any other clarification for the record?
Judge Oakley bound the case over on count 3 only, meaning the prosecution cleared the probable cause threshold on one charge, but the remaining counts did not survive the hearing. But the bind over is not the end of this Fourth Amendment question. In Michigan, a defendant can file a motion to suppress at the circuit court level, and if a circuit court judge finds that the initial encounter with Lloyd crossed the constitutional line, the evidence seized as a result of that stop could be excluded entirely, under the exclusionary rule. Without that evidence, the prosecution's case on the surviving count becomes significantly harder to sustain beyond a reasonable doubt. What makes this case significant beyond the outcome is the broader principle at stake. The Supreme Court cases the defense relied on, Terry v. Ohio and California v. Hodari D, exist precisely to define the moment a police encounter becomes a constitutional seizure. That moment is not when handcuffs go on. It is when a reasonable person would no longer feel free to leave. And in this case, that question was never fully resolved. It was only decided at the probable cause standard, not the higher standard that will apply at trial. If you think the officer had enough reasonable suspicion to tell Lloyd to come over, drop your verdict in the comments and subscribe for more cases like this one.